shortening, the Supreme Court has pretty much said it doesn't exist. All the procedures, all the niceties, and this is not supposed to be a political speech, but we can talk about some of the antitrust laws that have been eviscerated in the last 8 years. And the securities laws that have been eviscerated in the last 8 years, and the cases that have come up before the Supreme Court, not only in the antitrust context, but the ones that are working their way through the system in our business, which pretty much, I mean, you get what you pay for in terms of the Supreme Court, and we're getting a court that's really not going to find, any causes of action, and it's going to set the bar so high with respect to a lot of these cases, which are typically the class actions. But that's really important because if you have a case where, for example, recently American Express this summer paid $100 million to settle a class action against it, that its brokers were selling shelf space funds. They were favoring the recommendation of funds where kickbacks, payments were made to American Express by these mutual fund issuers so that American Express would go out there and promote these funds, or brokers would promote these funds. Clear conflict of interest because most of these funds all ranked in the bottom third of Morningstar. They were the lowest return. They were some of the worst performing funds by Morningstar. But yet American Express sold these to all their clients because they had reduced ticket charges. The broker would get a reduced ticket charge. If the broker had to pay $30 to process a transaction, maybe they would be free for these shelf space funds. Or we see different payouts. Brokers, they bring in $1 worth of commission. In a traditional brokerage firm setting, the broker-dealer might pay them, I don't know, between 35 and 45, sometimes even 50% of that dollar in the form of commissions. So if I'm a broker and I go out and sell a Vanguard fund or a fund that has merit, let's say, I might only, or a non-proprietary fund, I'm only going to get a 35-cent commission. But if I sell the house fund, the proprietary IDS fund, the proprietary Morgan Stanley fund, the fund that the issuer is my company, the issuer is related to my employer, I'm going to get a 50% payout. So what we have is a conflict of interest where the brokers are selling the proprietary securities, not in an effort to fulfill the underlying investment objectives of their client. No, they're doing it instead to line their own pockets. And that's a breach of fiduciary duty. That's a fraud. They should tell the client, oh, I recommend you buy the securities. And by the way, the reason I'm recommending this is because I get paid more money. But that would be full disclosure. That would be, giving you the omission that was omitted when they sold you those particular securities. So we like to think that the discovery guide and things like the ability to submit evidence are really important, and they're more than just procedural, they're substantive because they affect your substantive rights. Now, another thing we passed out last week, or at least Sam said, was when there's been a big movement, probably in the last 2 or 3 years, where we all know about the tech wreck cases. We saw a big bubble, and you'll see in your case notes. From 1998, 1999, there's generally about 4,000 or 5,000 cases that were filed before an ASD. That number went up to almost 9,000 or 10,000 in 2001, 2002. It started to fall up a bit in 2004. I think 2004, you can tell they made it up to docket number like 7,000. So 2004, there was probably a lot less. I know it's actually in your materials. You don't have 2004, but 2004, it went down. It went down to about 7,000. This year, we're in October, I think they're up to like maybe 4,000 in terms of docket numbers. So this year, we'll probably see about 5,000 cases filed. 50% off what it was at the high, let's say in 2001, 2002. Because all those cases have worked their way through the system. People who, no matter what your broker recommended in 1998, 1999, you made money. You can throw darts at a dartboard, have a monkey pick your securities, the exuberance that Greenspan spoke about, the irrational exuberance, where no matter what securities you purchased, they would just go up. Well, those unsuitable recommendations, no matter how risky they were, they all hit home in March of 2000. We saw the tech bubble bursting. That lasted it started to get better in the summer of 2001. We saw in 1 month in March of 2000, securities prices went down something like 13%. Went down in March, went down in April, went down in May, and went down in July. And August it started to come back up again. It was, oh, it's over. This little bear market's over. It's just like 98. Things are just going to keep going back. All the old models, and for people who study portfolio management and securities analysis, the old Graham dot, you look at price to book value, you look at return on equity, you look at fundamental considerations when picking securities. Well, all that went out the window. You had this guy over at Penn State.